It's 6 o'clock. Good evening. This is Deusdedit Merced. Today is Thursday, February 9th, 2017. This webinar is being recorded. In a few minutes, Perry Serkel will discuss the failure to implement claims under the IDEA. Joel, Seth, and Lynn Beekman will join him. Thank you, Joel, for assisting tonight. As always, I have to review a few important items before we get started. First, as I informed you via email, we now can offer CLE credit when viewing a recording of a webinar program. This option gives you greater flexibility in meeting the New York State training requirements. Hearing officers who select this option will be given approximately 30 or so days to view the recording and return to me the affirmation with the correct codes. The affirmation for those who use this option will also include between 3 to 5 attentiveness questions. For example, during the discussion of case X, what did Deusdedit say about what might have been the most important aspect or piece of the decision? Those types of questions, nothing very substantive, just making sure that you were paying close attention to what was being said. There will be 3 to 5 of those on the affirmation. You're expected, obviously, not only to get the codes correct, but as well as the answers to these questions. These are not only for the New York certification requirements, but it's also a CLE requirement that we check for attentiveness when you are viewing a recorded program. The second item I want to review with you is with respect to today's webinar. An affirmation form was included in the email I sent you with the training outline. As I said earlier, while we were waiting for folks to come on, if you can't find that affirmation form, on the control panel, I've uploaded the documents you need for tonight's presentation. One of those documents is the affirmation form. It's under the tab for handouts. If you click your mouse over the document and press on it, you will be able to download those documents directly onto your computer. So if you don't have your affirmation form in front of you and you need it, you can easily do that right now. At various times throughout the webinar, Perry will display various codes that you must write down on the affirmation form. The codes will not be read out loud. I repeat, the codes will not be read out loud. The course code is now going to be displayed on your screen. So Perry, why don't you advance one slide, please? The course code is now on your screen. Please write this course code number on the affirmation form in the designated spot for the course code. Submission of the affirmation form with the correct codes is required by the New York CLE Board and by NYSED for continued certification as a hearing officer. Please keep in mind, as NYSED advised you in July of 2015, only IHOs who participate in the entire session of the live webinar program would meet the requirement for participation in the update training and are eligible for CLE units. CLE credit will not be awarded and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you viewed the live program for the full 2 hours. Partial participation will not be accepted. GoToWebinar tracks the time a participant signed on and off to view the program. I must receive the affirmation form by no later than Friday, February 17th, 2017. Friday, February 17, 2017. Affirmation forms received after this date will not be considered for CLE credit, and NYSED will be informed that you have not met the training requirement. Third, all participants, as you are now, are muted throughout the duration of the webinar. It is our purpose today to answer as many questions and to receive as many comments as time allows. Should you have a question or comment come to mind during the course of the presentation, we ask that you share either the question or comment using the control panel that popped up when you logged in to GoToWebinar. In that control panel, there is a question dialog box with the wording, type questions here. Perry will pause to take questions or comments throughout the 2 hours as time permits. Finally, as I indicated in my email attaching the webinar materials, at the conclusion of the broadcast, a window will pop up that will give you the option to submit feedback through GoToWebinar. Please take a minute or so to fill in that feedback form. It will then be sent to me vis-a-vis the GoToWebinar software. With that, I am now going to turn tonight's program to Perry, Joe, and Lynn. So Perry, it's all yours.
Thanks, Dave Steady. And good evening, everyone. I hope that you are safe and warm on this snowy day. As you see the overall title here, we're addressing what some regard as the third dimension of FAPE, or denial of FAPE, the first two being procedural and substantive, as first established in the Rowley case in 1982. This is a dimension that has arisen since Rowley, increasingly in recent years, and something that the purpose of this webinar is to sort of sensitize you or make you aware of this dimension and get you prepared so that you can effectively deal with it in those decisions where this issue arises. The purpose of the webinar then is to familiarize you with the various approaches, with the understanding that we purposely picked an area to give you early warning and to be able to have the opportunity and challenge to contribute to that is not fully crystallized yet, nationally as well as, or more, even more strongly in the Second Circuit. And thus, please be prepared to not have an allergy to ambiguity or imprecision, because what we'll be examining is a slowly developing area that is not completely coate or crystallized yet. The significance to you, well, first, these claims are increasing in frequency. Someone like me who regularly reads both hearing officer and court decisions, I've noticed that there's an ascending trajectory of these kinds of cases, and with the increasing frequency comes a more nuanced or more complex issues within this overall claim. The claim, again, being from the parent's point of view that the district has failed to implement one or more IEP provisions, and that is a denial of FAPE. This is both a problem for you because, as you'll see and feel in this webinar, everything is not as precise and crystal clear as we'd like. It is somewhat like the area of compensatory education, which we previously addressed, and by the way, has slowly started crystallizing further because a Second Circuit case since our webinar took the view that we thought it was developing, which was that a denial of FAPE need not be gross for compensatory education unless the child is over 21, which is not the typical situation. And it's not just a problem, it's an opportunity, because many of you are very savvy folks who have very solid ideas as to what is equitable and fair for both the student and the district. And rather than just sort of by rote following what the courts sort of hand down to us, it's an opportunity for you to advocate and justify a particular approach that may well become the crystallized view that binds the rest of us in the Second Circuit, and the Second Circuit has a leading position nationally. Be aware that not only we have issues of lack of crystallization, but we have notions of confusion for us as well as for some of the courts, because there are some overlapping claims that are not the same but sound the same. For example, the last webinar that Dave Steady did had to do with not only the notion of retrospective evidence under the RE decision, but also, because that's where it becomes intertwined and most difficult, for claims of, I'll get ready for this now, and that is ability or capacity to implement. Now, the problem is that we have the notion of implement there, the notion of non-implementation. But that is differentiable from what we are focusing on today, and we'll spell that out with more clarity. The overall organization of tonight's rather ample time for us to really get into this is first, based upon some of the cases in our jurisdiction and elsewhere, I had developed a brief case scenario that is illustrative of the kinds of failure to implement claims, or FTI claims, that we would see. And I'm going to ask the panel, and welcome from you as well, your initial sort of baseline intuitive impressions as to if you did not have the awareness of all the little nuances. Just as a hearing officer faced with a case like this, does it appear to be a denial of FAPE or not? And that would be just as sort of an initial impression, a baseline for all of us. Then we will then get into the sort of didactic part where we look at what has developed to this point. And that first threshold bullet is this separating out or differentiating other claims, such as the ability to implement claims. Next would be to show you the sort of menu that is developed to this point nationally, which forms a continuum of alternate approaches that do not have crystal clear bright lines between them, but nevertheless you can perceive a continuum from a very strict approach, strict in terms of district accountability, to a much more relaxed approach. And they seem to fit within three basic segments, or three different approaches that we will look at. Then we will focus more specifically on our jurisdiction, the Second Circuit, more specifically New York, and take a look at what seems to be the choice as of now. And it's not clearly settled, but it seems to have initially gravitated towards two of the three approaches without clearly picking one or the other, but it's still not clearly settled, which again is a problem and an opportunity. Then we will come back and revisit that case scenario, having now been familiarized with these three different approaches, to sharpen our own application as to which approach seems to be most sensible, and how does that apply? What is the outcome? Does it change our initial impression of whether there was a denial of FAPE? And finally, some practical pointers to summarize useful ways of applying this information. And when I say shared identification, it's because, again, I primarily welcome Joel and Lynn in terms of their insights, but also to welcome those of you who would like to share with us your impressions and suggestions. So with that, let us take a look at the case scenario. Now, you have a separate document, as Dave Steady had pointed out, for you to download that gives you more detail, but I've attempted here to summarize the relevant highlights of this case. And so we start, of course, with the individual child, who in this case is identified as a sixth grader in a middle school environment, that is with separate classes and separate subjects for those each of those classes. So a sixth grader who has the previously the CSE has identified this child as eligible as having a language-based specific learning disability. From the facts of the case itself that I pulled this from, as well as more typically, sometimes you will find that it is not specific to any one of the 8 areas of SLD, such as reading fluency. And so this is fairly typical of that sort of imprecise notion that it is one or more areas that have to do with language, such as reading, oral, and oral comprehension. And that the child has a history of developmental problems that may or may not fit into a particular classification, but at least are relevant to show that the child's issue is not just this diagnosis of SLD, but has accompanying learning-related issues. Now, we're in the 6th grade, at least initially in this case, and so toward the end of the 6th grade, the parents participate, and in this case, actively, with the other members of the CSE to develop an IEP for the following year, for grade 7. And the sort of first relevant provision here that becomes a basis for the parent's claim of FTI, or failure to implement, is that in grade 6, the child had been integrated or included in 3 general education classes, excuse me, and now it has been reduced based upon the team's impression that the child is having some difficulty academically in the general ed classes and might do better to have the 3rd class change from a general ed class to a reading specialized class, because reading is one of the issues of this child's learning disabilities. And so that's the second bullet, the sort of trade-off. We go from 3 to 2, with the 3rd becoming this small specialized class having to do with reading improvement. The child's IEP for grade 7, similar to grade 6, is 2 different related services, each for 1 hour. And by the way, I think the original case scenario might have been a little ambiguous in that one might have thought that it might have been 1 hour between the 2. But to clarify that, 1 hour of occupational therapy per week and 1 hour for speech and language therapy. And that is the language that in the IEP, talking about where it talks about frequency, that it would be 1 hour per week. And finally, and here we get into limitations of technology, limitations in terms of my ignorant knowledge, as well as the fast-moving developments. But at least when this case arose, and there often is a time lag, a fairly substantial one, until it gets to someplace like the Second Circuit, but that this child has an assistive technology device listed in his IEP, which happens to be called here NEO 2, NEO being a commercial tablet-like sort of portable computer that has specialized software and communication facilitation, if you will, including for issues like spelling and reading, more than just sort of a generic device. So this customized device, which is now in its 2nd stage of evolution, that is, it originally was the NEO, now it's the NEO 2. What it says in the IEP is that the child will have access to the NEO 2 as needed. And that language, as needed, you may have noticed, is in your more detailed factual scenario. Moving down then, we go to grade 7 and we get through to the end of grade 7, and that's when the parent files their claim. And their claim has multiple prongs, including an allegation that there was a substantive denial of FAPE, also various procedural violations that the parent argued amounted to a denial of FAPE. But the relevant one for us, the 3rd dimension, is that additionally and alternatively to the first 2, the parent claims that there have been, and the parents claim 5 allegations of non-implementation, but to boil it down to so that we can focus in a limited amount of time, after you as the hearing officer receive and evaluate the evidence, you find that the evidence is preponderant for 3 of the 5 alleged failures to implement. One is the parent has argued, and you conclude after looking at the testimony in the exhibits, that the consulting special ed teacher, who under the IEP explicitly is supposed to be part of the child's general education of those 2 academic classes, there's supposed to be a consulting special ed teacher there, as was the case in grade 6, except that this teacher, unlike last year's teacher, whether it was a different teacher or the same teacher, this teacher does not have certification to teach grade 7. Now, the evidence is preponderant that that is a fact that you have found. Its legal significance will be up to you, but from the parent's point of view, the parents argue that the lack of certification is in effect like having an aide there or some individual who doesn't have proper training, that when it says in a general ed class with support from a consulting special ed teacher, that under state law that teacher is supposed to be certified, and that teacher was not. And thus, from the parent's point of view, that is an egregious deviation or failure to implement the provision having to do with the 2 academic classes that this child is supposed to be participating in as part of FAPE. That we're now moving to the second of the 3 where the evidence is preponderant. You find that the child has received occupational therapy and speech and language therapy, so it's not a complete like they didn't get any, but when you look across the year, the consistent delivery was on a 50-minute basis, that the child received actual services for 50 minutes, and then the child was excused back to their class or otherwise was not receiving occupational therapy or speech and language therapy. And when you looked at the evidence, you found that the other 10 minutes were not just a sort of blatant shortchange, but the rationale or rationalization, depending upon how you view it, was that the 10-minute difference between 50 and 60 was because these therapists have to move around, and thus to go from class to class, much less school to school, they need time, as well as that there's got to be some time to sort of prepare and or collect some data and monitor this data. And so that 10 minutes is sort of a transition preparation segment. From the district's point of view, that should have been understandable, and it was a de minimis, if any, deviation. From the parent's point of view, their argument will be, for example, in closing arguments, Your Honor, please do the math. 50 rather than 60, because it says 1 hour, and a normal person would understand 60 to be an hour, amounts to 83%, not 97% or something that was, you know, very close to 100% and maybe arguably de minimis, like the absence of an occupational therapist for one week session, but 83%, which is argued to be material, substantial, significant, or whatever language you'd like, meaning that there should be a remedy for this. And finally, the assistive technology device that it said would be available to the child or accessible to the child is actually not where one would normally think about accessibility, since when the child needs it and the child is located, presumably, according to the parent, it would be in the classroom. And yet it is in a relatively remote location within the school building in the former library, now media center, and thus was not readily accessible to the child. And you found that it was in the library. But what you also found, and that the district points out to you in its closing argument, is that indeed, number one, if and when the child needed it, the teacher expressed the ready, willing, and ableness to send someone down to get it for the child, that the child, when reminded of it being there, declined and often ended up using a more generic computer device that achieved the same purposes apparently in the classroom, and thus even if it was a deviation, it was in effect harmless error and just a mere technicality. At this point, I think hopefully you have a good idea as to what the claims of FTI are and what the arguments are, and before getting into any nuanced notion of exactly what's the standard, if we can turn first to Joel.
Perry, before you turn to Joe,
Yep.
I have two questions from the audience asking for some clarification about the facts.
Yep.
The first is, what is the location of service for occupational therapy and the speech and language therapy? Is the service delivered in a separate location or the general education classroom?
Yep, that's a good question. And the answer in this case is that it was a pullout, meaning that the location was outside but very close by to the classroom, as it was in the previous year in middle school.
And the second clarification question I received is, was the teacher certified in special education?
And the answer is yes, the teacher was certified in special education, but, and here, frankly, we may have to manipulate a bit the law, because I frankly do not know whether New York has, some states have generic certification, which is that if you're certified in special ed, it's all grades. But let's just assume for the sake of argument that the teacher is certified much like an elementary teacher for a given set of grades, but that his or her certification does not extend beyond the elementary grades to what is here a middle school or secondary grade. Okay?
Thank you for those clarifications.
While you were doing that, I wasn't sure, Dave Steady, whether you wanted to do the code now or have us continue with the debriefing of the case scenario. We're going to do the debriefing, just has to do with the sequence.
Is that the next slide that comes up?
Yeah.
Yeah, then you can put the code up there for a few minutes. Code number 2.
Go ahead.
Yeah, no, code number 2, folks, is up on your screen. Please write code number 2 on your affirmation form. We will keep it on there for a few minutes, but code number 2 is on your screen. Please write it down on your affirmation form. Please note that codes can be alphanumeric. It can just be words. It can be just numbers. It can be a combination of that. The code itself is, and I know it sounds silly for saying this, but it's come up in the past. The code itself, it follows the designation, code number 2, colon, and that's a code, and at the bottom I clearly write code number 2 on the affirmation form. So code number 2 is what Perry is right now highlighting with his pointer. That's what you write on your affirmation form. So I'll keep that on there for a few minutes, or Perry will do so, and then he can start. I have a few more clarification subjects, questions, I should say.
Yep.
What subject may have been missed when 10 minutes were in question?
Frankly, I don't know the answer to that, but from the parents' point of view, they acknowledged the fact that they knew that the child would be missing some instruction and had participated in selecting the period for the pull-out service so as to minimize the instruction. So their argument, I mean, there is an alternative argument. As a matter of fact, there's a ongoing class action case in New York having to do with pull-out services. But our focus here about non-implementation is regardless of what subject the child missed, the parent's argument is the opposite. It's not the failure to receive that subject. It's the failure to receive the 1 hour of pull-out service.
Okay. So while you're gearing up for the next thing, I just want to clarify.
Harry, can I ask some questions?
Yeah, one second, Joel. I just want to clarify. Code number 2 is on your screen. Code number 2 is the second code that we've shown. The first one is labeled course code. The initial code is labeled course code on your affirmation form. So you if on your affirmation form, write this code that is on your screen now under the label code number 2, and they're labeled just the same as they're labeled on your written affirmation form. Okay. So now, Joe, I'll turn that to you so you can ask your questions. Thank you.
Okay, I have a couple, and I'm going to start with the third part of it regarding the computer. That's an obsolete piece of equipment, and
Yeah,
all the dealings that I've had is that they want the child to have with them the unit that they're going to use all the time to help them through language or dysgraphia or whatever it is. And so having it in their possession makes sense. Having it in the back of the room even doesn't make any sense. And every case I've seen, almost now every child that has a laptop or an iPad. That's where we're going.
Yep. I agree with you. But again, Joel, and I tried to make this clear, we're looking at a case now that is like 4 years old. So at the time, it was not obsolete.
Right. Now, so, I know the equipment.
Okay, but I'm just saying at that time, it was not obsolete, and there was not sort of iPads, etc., in the room. There were a couple of desktop computers in the room, and that's what the child ended up using. But there was, so I agree with you technologically, and as a matter of fact, in constructing this, I had problems trying to find something that was relevant today. Although, ironically, I just read another case today where there was a more sophisticated laptop. But the
iPads have software.
But let's not use as the logic here that it's obsolete and therefore no denial. Let's assume. No, but
my point is that in our current thinking, that the use of the technology is all the time in all the classes. It's not a separate subject. It's every time the child needs something, he has it in front of him. In terms of writing or reading, it can be large print. It can do all kinds of things.
But if I understand you correctly, that would strengthen the parent's argument, if that's generally understood, that as needed meant the whole day.
Absolutely.
Okay.
Absolutely.
Thanks for the clarification. Did you have a second point?
The second point is just clinically within the school district, what is a session defined as for OT or speech and language? In most cases, it's a 50-minute session with 10 minutes of writing notes and getting ready for the next session. The transportation time I disagree with. I think that's irrelevant. That they should not handle that. But what's this district policy on what is a session? What is an hour session? In my experience, it's normally 45 minutes to 50 minutes is a session, and then some time for keeping track of it.
Yeah. But again, let's not impose your own experience on this case. In this case, the district, number one, does not have a policy. That is a formal policy. But to the extent that there's questions or evidence, it is true that when we question the therapist, they say that's their normal way of doing business.
That sounds normal.
Yeah. It is equally true that for these parents, that they testify sincerely that they are not in a bubble, that they're representative of other parents, and their understanding was that 1 hour meant 1 hour. It was not a session that's at issue, but an hour. Their view is if the district requires time for transition and preparation, that would be built in beyond the hour. My child gets 60 minutes of service.
Well, that goes to show how important it is to have good communication when you're setting a program up.
Yeah, but it also gets to show that often the cases we see is when there's not good communication.
Exactly.
All right.
Exactly.
So
the third area.
Now, what's your view as to, if we take each one of the three, just an initial impression?
Let me get back to the first one, consulting teacher.
Yeah.
The concept of consulting teacher is to facilitate return to the mainstream from special education. And the consulting teacher, as I understand it, is to work with the classroom teachers to help them service the child in a regular educational setting. It's not to give counseling. It's not to give service in the classroom. It's working indirect with the teachers.
And thus?
Therefore, the child's certification is, if it's a special ed certification, there's a secondary special ed and an elementary certification. Unless you're teaching the course, you don't need to be dual certified.
So if I understand you correctly, if your initial impression is no denial of FAPE, because since the teacher was not providing, in your understanding, direct services to the child, thus certification is irrelevant.
Except special ed certification.
Oh, and that's why the question of whether there was. And if the teacher didn't have special ed certification?
They can't be a consulting teacher.
So then there would be a denial?
Absolutely.
Even though there was no direct service to the child?
The skill set that a teacher would bring, a special ed teacher would bring to the room to assist the regular teacher in managing this child in the classroom is what this is all about. Without that skill set of a special ed teacher, it would be useless.
Okay, let's go to the second bullet. By second bullet, I mean you asked the question before about session. I gave you an answer. Now
that's a communication issue.
But based upon the testimony that you had, which was conflicting, that is, what the understanding of the therapist was versus the understanding of the parent with no official policy.
I would have to ask, and I just can't make a ruling on that because I really don't understand how much communication did go on.
Okay.
I've not seen an hour being a real hour. An hour is usually less than an hour in any clinical setting.
Okay, and then we go to
the third one, the equipment. I agree with the parents. If they're going to have a child, using technology, the technology is not a separate subject. The technology is to be used with the child throughout his day, his or her day.
And it didn't affect you, just to be sure, at least initially here, the argument the district made that, well, the kid never really demands it anyway and has an alternative within the classroom.
I would assume that with any child having to get specialized services, that if they're different from the services given to other children in the classroom, a lot of kids reject it.
Very good. Thank you. Lynn, could you give us your initial impression on these three claims?
Well, on the first one, on the consultant teacher, my answer would be there would be a failure to implement, but I'm not sure it's of the IEP because rarely does the IEP ever indicate the qualifications of the teacher, but it might be of a state certification requirement. So my answer would be yes.
Fine. Understood. And by the way, you do point out, and that's a good point, and it also reinforced what Joel had said, no matter how much effort the parties make to make an IEP clear, there are always certain inferences as to what an hour is, or in this case, whether the teacher will be certified or not certified, since they often don't say it one way or the other. Okay, the second one?
I might note in regard to this, I've had this come up, and I've seen teachers who had a lot of paper they could put on the wall and they weren't worth a darn. I've also seen teachers who didn't have hardly any paper, weren't certified for the area in which they were involved, and they were absolutely wonderful with the child. So quite frankly, I ask those kinds of questions before I would make a ruling with regard to the lack of certification, technical certification. It might be a denial, but I'm not sure the child may actually have benefited given the individual strengths of that teacher with that particular child. But moving on to number 2, the OT service provider. I see this somewhat as Joel did. I have actually had this come up, and the practice varies all over the place, and I would need to know what was the understanding and what was the discussion with regard to what 1 hour, and I'm assuming the IEP said 1 hour.
Yeah, it did.
Okay, and if that was the case, and they'd had this OT in the prior year, so we not only have this year, we have experience of a prior year, or maybe more, where there were discussions with regard to what 1 hour included, 50 minutes plus the other stuff, or a total of 50 minutes of direct services. I think you got to know that in order to determine whether there was in fact a denial on the OT and technology.
That's a good point, but let's say the parent takes your point and says, yes, my child did have the same provision last year, but I really had no idea. It's sort of like statute of limitations. What's the date of knowledge or reason to know? I first knew or had reason to know about this violation this year, and if I had known it last year, as a matter of fact, for compensatory ed, I would want it for both years.
And then I'd find it a denial. I mean, I'd find it was fair to implement.
Huh, interesting. And the device?
Well, whoever wrote this IEP has committed what I used to tell people writing IEPs is a cardinal sin. You never put as needed, because I don't believe it is enforceable, because you don't know the criteria that are going to be utilized to determine when it is needed, and you do not know who's going to make the decision with regard to whether it's needed or not, the student, the teacher, or in consultation with the student. So on this one, I would say, based on the language in the IEP, I couldn't, on the face of it, say that there was a denial. Failure to implement.
And what about, let's say if Joel had been the expert witness and told you that it's implicit that, although it said as needed, that the child would presumably need it all the time? You'd still say, why did...
Well, then the other part of that is the OT would probably be the person implementing the use of the equipment as part of an OT service.
Okay. Well, at this point, let's move on, only because at least you've given us a very good flavor of the sort of variations and points that I frankly I hadn't thought about. Dave,
Terry, can I jump? Yeah, can I just jump in here? I have a couple of comments. Some of it is reactions to what people were saying, so it might have passed the point that they're reacting to, but I want to offer it so that people know that I am reading their comments. And one comment says, in our state, NYSED does not consider travel and documentation time as part of direct service time reflected on the IEP. The next comments, and you can stop me.
That one, now just as we go along, so that one would seem to, if I heard you correctly, would seem to support the notion that it should be a full 60 minutes?
All I have is the comment, so
okay.
So I don't know where the line of thought was going with that.
Okay.
The next comment is consultant teacher time may be direct or indirect as per state regulations.
And that's to clarify, you know, we have different understandings, but Joel's notion that the consulting teacher would only be helping the regular teacher, not provide direct service. So apparently we have some varying practices or understandings.
Right, and then and another hearing officer also reiterates, IEPs in New York are supposed to indicate if consultant teacher service on the IEP is direct or indirect service. And I remember from my own practice in New York, the regulations do specify whether it's direct or indirect, or supposed to, the IEP needs to say that. As to certification, certification requirements are very complicated due to changes in state requirements and highly qualified teacher under NCLB.
Let me just insert a quickie on that one, just because it gets everyone up to date on a little issue. Number one, there's two issues. One is certification, the other is highly qualified. And for highly qualified, in the regs, the IDA regs, it said that that would not be within the jurisdiction of a hearing officer for denial of FAPE. But the most recent passage of the successor to the NCLB, the Every Student Succeeds Act, eliminated the requirement of highly qualified, and the IDA has been amended to conform to that. Thus, although whoever made the comment, it's useful for us to understand the distinction, it is no longer a meaningful distinction because it no longer exists as far as a requirement under the IDEA.
Okay, from SED weighed in and shared some information from their on teacher certification. SED, and I think this is to clarify the certification of teachers, grade level, all New York State certificates are issued for work in specific grade levels. These include early childhood, birth through grade 2, childhood grades 1 through 6, middle school or middle childhood grades 5 through 9, adolescent grades 7 to 12, and all grades pre-kindergarten to grade 12. That's SED sharing what the regulations say. I have a couple of more comments and questions.
Giuseppe, just one point I'd like to make. The consulting teacher is 200.6D in the state regulations and does discuss this pretty comprehensively.
Okay. Okay. I have a question from a hearing officer. Isn't the ultimate issue under the IDA whether whatever the district offered the student was reasonably calculated to lead to educational benefit? How much educational benefit will be determined by the Supreme Court in the case currently pending before it? That being said, shouldn't the implementation issue be decided by determining whether whatever was offered, regardless of the extent to which it varied from what was recommended by the CSE, reasonably calculated to lead to the requisite educational benefit, a question of fact?
That's a nice transition into where we're going, but I don't know if there's anything else you wanted to
let me just go through this quickly. I think most of it is just comments. You cannot leave this to the conversation between the district and the parent. This is a policy issue on the state level. And again, because it's a comment that's train of thought of the hearing officer, and we probably have gone beyond that. I don't know what she's referring to. In real school, transition occurs in all subjects. Reading time to get into groups, get materials, etc. Lose 5 minutes at least during all subjects.
Interesting. Reminding us that this is a more generic kind of implementation reality.
So I believe those are all the comments I've gotten now. Okay. So I guess you can transition to where you need to be now.
Good.
Thank you.
Thank you, and thank everyone else for your not only Joel and Lynn, but it turns out that the rest of you have knowledge to share that's well beyond mine and are very helpful here. The one comment that serves as the sort of best transition to where we're going that we'll see momentarily had to do with that notion of reasonably calculated and the Supreme Court. That leads to this slide, which is essentially, where does this FTI fit within the various claims for denial of FAPE? Let's review them for a moment, of which there are theoretically 5. I've only listed numbers 3, 4, and 5 on this particular slide. Excuse me. Inferably, the two that are missing are the two that are just sort of we all take for granted. The Rowley procedural violation of FAPE, which in Rowley itself, although mentioned as far as an overall standard having to do with compliance and the emphasis on procedures, Rowley did not actually address and apply the procedural standard because there was no alleged procedural violation. But more recently, as we have had repeated ad nauseum, the courts gradually developed and the Congress ultimately codified the two-part test. And I'm stopping to reemphasize it because it squares with the notion again that the person talked about before, which is essentially getting to it. If there is one or more procedural violations, does it result in an IEP that's not substantively or reasonably calculated to benefit the child, which is the ultimate purpose? That leads to the second type that Rowley did address, which is what's the substantive standard? Reasonably calculated to achieve benefit. And that reminds us, because it ultimately becomes important in our practice, but also because it has indirect significance here, as you'll see when we get to the materiality benefit approach. But what is the substantive standard? An issue that the Supreme Court is currently considering. They have had oral arguments in the case, which is the 10th Circuit case, Andrew F. versus Douglas County. And most people are predicting that we'll find a decision in late June or early July at the very end of the Supreme Court's term. And many of the folks who sort of watch the Supreme Court and listen to the oral arguments seem to be betting that the Supreme Court is going to raise the standard, although they're not sure in what way. One way to raise it is to say reasonably calculated to achieve, and then insert the adjective meaningful benefit. But at least at oral arguments, the various justices that weighed in on it, that wanted a standard with more bite, found that meaningful is not all that meaningful. And if you look at the lower court cases, it is hard to see a significant difference in the application of those two standards. And there are alternative standards, such as whether the child has made substantial progress in relationship to the general education standards of the state, which would be a much more rigorous outcomes approach. The point is that wherever the Supreme Court ends up in June and July can not only affect all of us in terms of potentially elevating the expectation, but to the extent that that person is correct, that benefit is part of a failure to implement case, it would raise that part of it accordingly. Now, as you digest that, that's all just background. What are the three that seem to be not addressed by Rowley and that get sort of confused with or intertwined with what I'm calling FTI, or here actual failure to implement? The first is that your circuit and with the exception of a couple of cases in DC and one in Virginia, I don't know another place that has with any frequency claims of ability or capacity to implement. And yet it seems to show up in 1 out of every 2 or 3 cases that at least get to the judicial level in New York. We're not talking about that. That is, although it has to do with implementation, it's an argument that the school or placement could not, it doesn't have the ability, it could not implement it. In distinction, what we're talking about is not could not, but did not. So going back to our case scenario, it's not like the parent at the end of 6th grade says, the middle school next year does not have the capacity to implement the IEP in terms of its general ed classes, its assistive technology, etc. That's not the argument. It's rather, in effect, a retrospective argument after the 7th grade is over, after we've had the period for implementation. Did the district do it or did it not? And if it did not, do we mean completely or to what extent? Now, there is a third, this intermediate one, that actually is not recognized anywhere at this point, but shows up in the Second Circuit in various New York cases. The parent typically, the posture of the case would be a unilateral placement to a private school, and the parent's rationale, among others, or alone, is that school, just based upon what I know about the sort of attitude, commitment, etc., that school, even if it could implement it, would not implement it. And the courts have said that's a entirely speculative, theoretical claim that at this point we do not recognize. And where we end up seeing it often is when we're dealing with that RE, retrospective or extrinsic evidence argument. The court says essentially, we're not going to allow any evidence, extrinsic or intrinsic, about that because we don't recognize that claim. It is too speculative to be cognizable. My point ultimately is, as a practical matter for New York hearing officers, is be careful when you have a failure to implement. Is it ability to implement, a could not, or is it the actual did not? And it's the actual did not that we're looking at here. Now, in looking at it, some of us are more visual, and so as we go through the wording of this and look at the cases, I'm going to attempt to provide a very sort of rough draft. It is not a precise, mathematically scientific, but just to reinforce the idea. And first we run into these words. By liability here, the gray area, I do not mean money damages in a civil law kind of sense. All I mean, and maybe I should have said that, is denial of FAPE. In other words, if you go back to that case scenario, and you take an area like assistive technology, and if Joel were the hearing officer, based upon his knowledge and insights, he concluded that that failure was a sort of blatant failure. It was a denial of FAPE. That's what I'm calling the gray area. On the other hand, when I say non-liability, all I'm really saying, bottom line in terms of ruling, is it a denial of FAPE or not? This is the not, that this is not a denial of FAPE. Now, with that sort of framework, we're now going to move into the three approaches as a continuum. Now, in the course material and the outline, you will see that the sequence is the opposite. And that's because in the course material, I was basing it on the cases, and chronologically, the first approach that surfaced in the year 2000 in the Fifth Circuit conceptually fits third, even though chronologically it's first. So I've reversed the order. I'm sorry that the two are not in sync, but we're starting with the strict side of accountability, a so-called per se approach, that if there was any non-implementation more than a de minimis, so if, for example, if we went back to the 1 hour, if it was 15 minutes on a given day or 2 days because, I don't know, the therapist, the related service provider was sick that day or had to make an extra trip or something that is very, very, very small. So there's a, instead of 100%, it was 99% implemented and 1% not. Anything that's so trivial that we shouldn't recognize, it wouldn't count. But anything beyond that trivial amount, wherever you draw that line, would be considered a denial of FAPE, regardless of the extent once you get beyond de minimis. And remember what that one person's comment was about reasonably calculated. Regardless of whether the rest of the IEP was beneficial, regardless of whether this kid made tremendous progress, a per se approach takes a sort of strict contractual approach. You promised to do it, you committed to do it, you didn't do it, And instead of feeling guilty, you should just compensate for whatever percentage beyond de minimis you didn't provide. If you understand that sort of strict approach, then the second place we look is, well, what authority is there thus far? And it turns out it is, in effect, de minimis, or very limited. First, some of you are aware that parents have a choice when they are dissatisfied with an IEP. They can come to you, and or they can go to the state complaint procedures process, which is outlined in IDA regs 300.1.51 to 1.53, and that ends up being an investigative process by a staff member at NYSED who would end up deciding if the complaint was failure to implement. And I found in a fairly systematic study that I just completed of various states that most states and most investigators use this per se approach. In my footnotes, for example, I listed as illustrative, not as an anomaly or as an outlier, but as fairly typical, a complaint investigation where the kid was supposed to get counseling for a half an hour, and for 3 weeks during the school year, the child didn't get it. All the other weeks they did. Complaint investigator writes a decision, has a factual finding of a 90-minute omission, concludes that 90 minutes is not de minimis, and regardless of benefit, without investigating benefit at all or the substantive side, orders as corrective action that the district provide compensatory education of 90 minutes of counseling, which, by the way, is a strict quantitative approach rather than qualitative approach. Beyond that, if we look at the cases, we'll find one case that is associated with the so-called, and you'll see the meaning of this momentarily, the materiality approach. The case is called Van Duyen, from the name of the plaintiff, and the decision was a 2-to-1 decision. 2 ended up saying we reject the per se approach. We adopt instead the materiality or material denial or the material deviation approach. The third of the 3 judges, however, said not at all. The team, the parents, and the district, in effect, negotiated or collaborated and arrived at what they said was reasonably calculated. And just as long as it meets minimal standards of being reasonably calculated, even if it's more, we're not going to fault the parent and make them provide compensatory ed. We're going to hold the district responsible to implement what the team decided. That was the Ninth Circuit dissent, but that wasn't the law in the Ninth Circuit. Thus, as you're digesting that, again, for those that are visual, along the bottom we have an axis that just simply says what is the extent of implementation that you find for this IEP. And if, so over here at this end, non-liability for de minimis, whether this is 98% or whatever you decide, it's a very limited area. Anything beyond that area that is not implemented is liability. That is a denial of FAPE and would lead to a remedy, the most typical but not exclusive remedy being compensatory ed. And if it is compensatory ed, we're back at a separate but overlapping topic of quantitative versus qualitative.
Are you going to?
Harry, can I jump in here for a minute? There was a comment on the per se approach. The per se approach is form over substance and takes the logic and intelligence of the hearing officer out of the equation. This process is supposed to be child-centered. How in the world can you find that a child who failed to receive 100% of the services recommended on the IEP, yet who made meaningful gains, was denied a free and appropriate public education? Hopefully we are a little more intelligent than that.
Could I add a comment?
Yep.
I think the best argument for the per se approach is if one looks at the definition of FAPE in the regulations, that's 300.17, where it says FAPE means special ed and related services that A, are provided free, B, meet the standards of the state, C, preschool up to 12th grade, and fourth, are provided in conformity with an IEP that meets the requirements of the rest of the regs. I think it could, I don't know, I can't recall, I haven't read Bobby R. or Van Duyen in so long, I can't remember whether any of them ever refer, including the dissent, to that definition. But that to me says, if they screw up on any part of that IEP, it is a denial of FAPE. Now that doesn't get to the remedy part, where you could have, obviously a technical violation, but kid wasn't hurt, so no remedy. I mean, we have that equitable relief factor in there. But to me, that's rarely considered, and I think that is extremely important.
Your point is well taken, and as far as I recollect, the dissent in Van Duyen cited either that reg or a related reg, but the dissent point, different from yours, was this is not the notion of technical. I mean, although there is the issue of remedy, the remedy is sort of automatic. It's not going to be a nullity. The remedy will be something to make up for the difference. If it's quantitative, it would be the exact amount that the child did not receive. If it's qualitative, you get into that Reed kind of approach, which could be more or less. But the point is, it's not like a procedural violation that's a violation, but is not a denial of FAPE. From the dissent's point of view, citing the reg and the approach that we're talking about, it wasn't in conformity with the IEP, thus was not FAPE, and thus was a denial of FAPE, not technical, but material. And by the way, the comment that someone made, to me, obviously that person is against the per se approach. But my view is talking about intelligence of hearing officers is sort of a name-calling kind of way to get at whether the per se approach. It seems to me that an intelligent hearing officer, just like I was about to say the supposed judge in the Ninth Circuit, but the dissenting judge in the Ninth Circuit is obviously an intelligent person. And he offered various rationales. And on the outline, and I don't know if we have time or not, I don't think we do, but if you look at the outline, I've listed about 7 or 8 arguments, and we get finished, I'm going to put Lynn's in because I agree with him. I missed it, but it's a very strong one. But there's about 8 arguments where an intelligent, rational person could argue that even if a child benefited, that in effect they would have benefited all the more, and what's the purpose of an IEP than to provide one? I mean, if you take it to its extreme, you could have an IEP that was completely procedurally in violation, and that offered nothing, but the kid made wonderful progress, then presumably somehow it was reasonably calculated because he made that progress. We obviously, however, are going to vary in our opinions on this from one extreme to the other, but let's at least all make sure we understand, intelligent or not, what the choices are. So I'm going to go then to the next approach, which is, notice the term Van Duyen. This is that Ninth Circuit case. Now, chronologically, we are now, if we go back to that case, that was in the year 2007. We'll ultimately get to the third approach, which is chronologically first in the year 2000. We had Bobby R. So this case was after Bobby R. The significance is that this case was reacting to what we'll see momentarily, which is the third approach. This court ended up saying that there is denial of FAPE, not technical, a actual denial of FAPE for non-implementation if the non-implementation is material and contrary to some of the comments that some of the hearing officers have made, which may be correct but fits with Bobby R., the Ninth Circuit has been very clear that whether the child, let me put it differently, whether the IEP is reasonably calculated to yield benefit is irrelevant. What is relevant is whether the denial of FAPE was a material that is more than minor. Now we're running into some wording problems here, because is minor the same thing as de minimis? I don't believe so, but you're going to have to make the essential nuance yourself. I can just warn you of this sort of wording problems here. But essentially, the way Van Duyen, regardless of what it intended, what it has ended up in the lower courts and in hearing officers that follow Van Duyen, is what they do is they look at the extent of implementation without looking at benefit, and if it's a sort of a major omission, then it is a denial of FAPE. And where you find that is in the years after 2007 in the Ninth Circuit and in scattered courts elsewhere, but if you look for a concentrated place which has had multiple decisions that are in my footnotes, there's a whole string of cases that have slowly evolved from Bobby R. to Van Duyen and have used what they call, and I find this helpful because material is sort of a fuzzy term to me, even though it's a legal term, but they have characterized it as a proportional, like percentage approach. Now, as you're digesting that, remember, here was the per se approach saying anything beyond de minimis. Now here, frankly, I've had some problems because of the lack of crystallization here. Because I was moving toward trying to get symmetry with the next step, I called it substantial or significant to try to come up with something that was more than de minimis, more I look at this, I'm tempted to say minor, but let me just think about this for a second. I was just still puzzling through what's the clearest way of expressing it. While I'm thinking of it, just for those of you who are more mathematically inclined, thinking of proportionality. What's the extent of implementation? If it's 98% under per se, fine. If it were, let's say, 85%, 90%, clearly more than de minimis. Here, what it's saying is we've got to lower it. Maybe it's 85, maybe it's 80, maybe it's 75, but whatever the threshold is, it is a more major omission or failure to implement. So do we call it substantial or significant? We could. I'm going to call it tentatively right now major. You're going to see why in a moment as we look at this other axis. But the point is, using the words of the Ninth Circuit, was there a material deviation or shortfall? If so, in the Ninth Circuit's view, denial of FAPE. Now, the Ninth Circuit, to fuzzy the thing, says benefit can be looked at, and if there's denial of benefit, that would seem to reinforce that it was substantial, but benefit is not a required factor here. That is just a sort of extra factor.
Now, to jump in there, Perry, for a minute, I got a comment that speaks to that. It is pretty hard to call something as more than minor without looking at the effect on the student.
Theoretically, you would think so, and I'm sure from when we get to Bobby R., that's Bobby R.'s point of view, which is that the two fuse together. As a matter of fact, if there was a denial of benefit, it must have been more than minor. The problem is it doesn't quite work the other way. How about if there's no denial of benefit, but sort of mathematically there was still a major deviation or shortfall? So I don't quite agree, but again, we're all of us are struggling with sort of where does benefit fit, and as you make your own decision as a hearing officer, you will find that it ends up with a label that if benefit really is very significant to you, you're going to be in the last approach of the three that we're providing, which was the first on the outline. If you're sort of wishy-washy on benefit, and it could be significant or relevant, but it's not deal breaker, then you'd end up with materiality alone. And by the way, when we get to the New York courts, I think they're somewhere they're in between the two. They haven't quite figured this out. But some of us, and I will admit my own inclination, is in the minority, in the distinct minority. In my view, not only is benefit irrelevant, but the substantiality major or more than minor is irrelevant. If you committed to do it and you didn't do it beyond a de minimis level, then you owe the child. But my view is not at all significant here. Now, to complete the continuum, we're moving next to Bobby R., which was the first Circuit Court of Appeals decision in the year 2000 that actually faced and addressed this claim of failure to implement. And if you read through the case, it is a little bit like a Rorschach test. It depends upon exactly how you interpret it, but if you look at the cases following it, they seem to end up, that was not on purpose here, they seem to end up concluding that for a denial of FAPE, you need both. You need a major shortfall and a resulting loss of benefit. However, unlike procedural FAPE, none of the courts, including Bobby R., at least this point, have approached it as two separate successive steps. In other words, I haven't seen courts that say, first I'm going to look at the degree of shortfall, and if it's major or material, then I'm going to look at whether or not it was benefit. They sort of end up fusing the two together, and sometimes they reinforce each other, but sometimes, in my view, they don't, and it just gets sort of lost in the equation. But to add to it, well, first let's talk about where. The Fifth Circuit is clearly in this camp. And the Third and Fourth Circuits, both in terms of at least one Circuit Court of Appeal decision unpublished and several district court decisions, they recite or cite Bobby R. As a matter of fact, they cite, not recite. You'll see why in a minute. They cite Bobby R., but in doing it, they're not very careful because, number one, they sort of intertwine this. But the other distinction, which caused me a problem in trying to visualize this, is this. If you really look at the clear primary language of Bobby R., it does not really use this kind of axis of extent of implementation, at least in its sort of pure form. Instead, what it talked about, and frankly, I don't know whether the Fifth Circuit did this consciously or was just sort of loose language, but what they ended up talking about, instead of substantial, now they do use these words, substantial or significant, but instead of a substantial or significant non-implementation or failure to implement, they talk about a failure to implement substantial or significant IEP provisions. Now, I have not seen courts that have actually recognized that significant difference. If you take the language literally, then what it would suggest is you'd first, remember our case scenario, you'd first look at the assistive technology and the consulting teacher and the related services, and you'd have to say, are those provisions substantial or significant as compared to being ancillary or peripheral or relatively minor or non-central provisions? And there would be then a distinction between the level of accountability for a significant provision, like for those of you who are sort of very strong on LRE, you might regard the two regular classes or general ed classes in this kid's IEP as being really the heart of the IEP. And there you'd be extra sensitive with regard to failure to implement. If on the other hand you regarded either the Neo 2 device because of its obsolescence or something else, or the therapies, or one of the two therapies as being relatively peripheral, then arguably, if you follow the literal language, then you would hold the standard of extent differentially for those provisions that are what now I just, because I didn't have a lot of space here and I didn't want to be repetitive, I called it centrality as a way of trying to capture, in short, this idea of substantial or significant provision. But my point is that it's not only a continuum from strictness, because the odds for those, if you did follow the per se approach, is the parent would win many, many more cases with this standard. And they would win the least percentage of cases here, because here we'd be looking at, number one, what several of you pointed at, the ultimate substantive standard of benefit under Rowley or whatever Andrew F. ends up telling us it is, and potentially whether the IEP, if you're following Bobby R. and citing it, looking at whether the provision is substantial or significant. So the clearest point is it's a continuum going from strict to relaxed. And it's much easier for the district to win here. It's much harder for the district to win here. But the problem is not only words like de minimis versus minor, much as major, but that really there are two different referent points. One is the IEP as a whole or any specific provision with no differentiation as to its relative significance. The other, under Bobby R., if you follow it literally, is you're looking at the centrality of the provision along with the extent of implementation. And where you draw the line becomes very difficult. Now, as you're digesting that, let's go back to data study, give you time to digest that.
So right now on your screen is their code number 3. Code number 3 is on your screen. Please write code number 3 on your affirmation form. We will leave it up there, and I am going to share with Perry some of the comments. One hearing officer has food in his mind, but related to what we're discussing. If one pays for a Happy Meal and you don't get a juice, then you're entitled to a juice, and in parentheses, de minimis, not a steak dinner. And then he says, if you order a cheeseburger and you don't get a cheese, and you don't get cheese, that equals total failure.
I like that analogy, but however, I don't interpret it quite the same, because it seems to me if we follow this Happy Meal notion, if I didn't get a juice, then I go back to the counter and I say, I understand I'm not entitled to another Happy Meal, and I'm not entitled to the hamburger, but it's not de minimis. It's not like you forgot a napkin. Juice is part of the Happy Meal, and my compensatory ed is one juice. Okay, go on.
All right.
Sorry.
That's okay.
It is dinner time.
Another hearing officer says you skipped over the materiality alone test, that it requires, and they're quoting, requires a material shortfall in the overall extent, end quote, of implementing the IEP.
If I missed it, frankly, it was just in communication, because both my sort of visual and the wording was that the materiality alone approach requires a material shortfall, where you draw the line as to what, and regardless of benefit. The hard part to me is what is material in that case. And I think what material is anything more than minor, and minor being something more than de minimis. But in any event, if I missed it, the comment at least reminds
Perry,
me of the...
Can I add a comment here?
Sure. Joel.
I think we're missing something. One is present level of performance. If you have a legitimate, measurable present level of performance, and you set up an objective in a measurable form that is based upon that present level of performance, you can tell by testing the child if there's progress or not. it's not quite as flexible as we like it to be. The problem is we just don't know how to write quality, present level, or performances that are measurable.
I respectfully disagree. And first, present levels of performance, at least viewed by courts, is procedural FAPE. And for that, the courts have applied a two-part test. Alternatively, that's substantive FAPE. It's talking about whether the child made progress, and it gets further difficult. It is further difficult in your jurisdiction because of RE, in that, and by the way, not just R. Excuse me.
No, there's apparently feedback. Joe, can you turn off your mic? Thank you.
Okay. My second point.
Lynn, can you turn off your mic?
No, I can't, and it's not coming from me.
Yeah, and maybe if I talk lower, does it repeat it? Are you getting an echo now?
No.
Okay. Maybe it has to do with volume. I was trying to speak louder because of what Lynn had said, but my second point with regard to Joel's notion of progress based upon present educational levels, which alternatively, by the way, one could look at in terms of progress in terms of goals, is that, if not procedural, is substantive FAPE. The baseline that we're looking at here for an FTE case is not present educational levels. The baseline here is what are the provisions of the IEP. Now, we've here had the issue of what does hour mean, what is as needed means. But if we get past that, if we get it clearer, and it doesn't say as needed, it says all of the time of the instructional day. It says 60 minutes of direct service. It says the consulting teacher will provide direct service. Whatever is clearly understandable to a reasonable person, i.e. the IHO, is the baseline. And what we're measuring in these visuals is what is the extent of implementation of whatever the IEP says, with one added gloss or nuance being, is it a provision that is central or significant? But in my view, clearly distinguishable is the notion of present educational levels.
Perry, I have a few questions and comments here, so I'm going to go through them quickly for quick answers.
Okay.
I know that it's 7:30,
Yep.
so I want to make sure that you...
Faster answers.
Yep. To what extent is Perry attributing positions in the various circuits to unpublished decisions? Isn't that a distinction that should be acknowledged in representing what the positions of various circuits are with respect to these issues?
I can answer that very quickly, which is I agree that there is a hierarchy. The footnotes in my outline, however, reveal which cases are published or unpublished, and I have relied almost exclusively on published decisions. And especially when we're talking about Babiar and Van Duyen, they are published Federal Circuit Court of Appeals cases. And if not every one, although it may well be every one, all of the lower court cases, or virtually all of the lower court cases, are published as well. Next.
There's another approach articulated, I believe, by OSEP in letter to Clark, which says whether an interruption of services constitutes a denial of FAPE must take into consideration the impact on the child's progress and performance. A denial of FAPE is an individualized determination made on a case-by-case basis.
It is true that OSEP has registered more than one and not consistent interpretations, including but not limited to letter to Clark. On the other hand, number one, if you look at them carefully, they're not directly on point having to do with failure to implement, although they're certainly related, like things like absences or interruptions. And second, that we're just talking about the hierarchy, OSEP opinions are clearly not binding.
Okay. Do you find that courts infer lack of benefit from a material shortfall, or do they really look for proof of denial of benefit, which might well be hard to prove in relation to the material breach? For example, how do you show that the lack of 10 minutes has a denial effect?
It's a very good point. And the answer is that the courts thus far, and you'll examine them for yourselves, but my impression of the courts is that they're very cryptic, that they have a much lower standard for thoroughness for themselves than they do for hearing officer decisions. And in general, what they do is they take, which I found for other violations in the procedural area, they take a holistic approach. That is, if the IEP as a whole was reasonably calculated for benefit, then those that use the Bobby R approach, in effect, excuse any deviations because they conclude that they were not material because of the overall benefit. And that's relatively easy to prove, at least as far as our experience in using substantive standard of FAPE.
So
two
comments and two questions. I'll read the comments first. It's never a good policy to allow the ends to justify the means. Here, it would encourage districts to develop policy of shortchanging students. The second comment, and a child's success is not necessarily.
I have to insert quickly.
Yep.
The way I interpret that comment is for those of you that are against the per se kind of approach, or against the material. In other words, those of you insisting on benefit this is a counter argument to that.
Okay. The second comment is a child's success is not necessarily determinative of whether the school did what it was required to do.
Same. By same meaning, I agree.
Two questions remaining. Does it make a difference if it is unintentional?
That's interesting. I have seen no authority one way or the other, but my guess is, frankly, that one reason I haven't seen any authority is I would think that school districts would never say, I intentionally didn't give the kid blah, blah, blah. And so if we just sort of look at our case, like the 50 minutes, they intentionally gave the 50 minutes, not 60, but that's because their understanding was that that was what an hour was. So I don't think a district would readily admit intentional, and if it did, it would certainly make it much stronger, but my view is whether it's intentional or not intentional. As a matter of fact, I read one case in our jurisdiction here where as a matter of fact, we'll get to it momentarily, but it's the Second Circuit case, unpublished, in AP versus Woodstock. The parent said that the IEP said the kid was supposed to have a aide in the classroom, and at least according to the parent's testimony, and there was no rebuttal, they didn't have another aide available, either because of staffing, budget, or whatever. So that was sort of intentional, and yet didn't seem to matter to the court. What mattered to the court was, did they provide it or not, and which approach was used to determine whether it was denial of FAPE. Last question.
And the last question just transitions you to the next topic, I believe, which has the Second Circuit adopted one of these three standards.
Great. Thank you to whoever asked that question. So now we get to the point, and if you're already sort of feeling the usual feeling of sort of some ambiguity and complexity, oh, here goes Zerkel again, it gets worse, unfortunately. In your circuit, it is more Rorschachian than in the Fifth or Ninth Circuit. And again, those who talk about unpublished versus published, the only decision we have at the Second Circuit level is a case called AP versus Woodstock, which is a relatively brief opinion for which implementation or FTI is only one of several issues. Most people know this case for one of the other issues, which is child find. But if you read that case and you're wondering, okay, which of the three approaches does the court use? Well, it doesn't seem to be per se, because it cites Van Duyen and Bobby R. It cites both of them along with an Eighth Circuit case, which happened, IHO, which happens to be off point altogether. And then when you look at the case itself, depending upon how you read it, one way of reading it is they just looked at it and they said, like some of you to the case scenario, none of these variations were really material, thus we don't have to reach benefit. But there is a part of the opinion which it's hard to tell whether it's separable or not, where the court essentially says this kid did okay anyway, so he did have benefit. So my view is it is very hard to tell from this case, number one, because it's unpublished, what the court is actually sort of as a binding matter choosing. And even if we give it great significance by citing both and applying them rather briefly and not reaching one issue that maybe they didn't have to reach even if it would have been relevant, it leaves, it seems to me, the problem and opportunity for hearing officers to use this in one of several ways that I'll talk about. But second, if you look at the federal district court cases, most published but some unpublished, as to what they have done since AP versus Woodstock, there have been, and you'll see it in the outline, approximately 5 cases that have slowly but surely addressed this issue. And they tend to mention Van Duyen and Bobby R. without clear distinction and apply them without careful application, although those of you that favor the notion of benefit being clearly a key, I would say that the majority of the cases end up using benefit, but they do not actually say, we're following Bobby R., not Van Duyen, and thus are using benefit as an essential criterion. And by the way, none of them, including the Second Circuit case in AP, none of them recognize or apply that nuance of the difference where they, even if they're using Bobby R., where is the significant and substantial IEP provision? It ain't there. Thus, it seems to me, and you may come up with a fourth better alternative, but with my little simplistic, non-intelligent mind with a continuum, it seems to me one way to go is to say what's good for the goose is good for the gander. If the Second Circuit and the courts have not taken a clearly differentiated approach, I'm going to just do a brief cursory opinion, cite Bobby R., cite Van Duyen, use benefit if it seems to fit, not get into the proof problem that one of you just pointed out about showing whether a particular denial resulted in it, but otherwise talk about holistically benefit. That's one way, and it may work. It's certainly doing no worse than the courts. On the other hand, for those of you who either are holding yourself to the standard that the courts recite of being thorough, and or for those of you who want to improve the judicial policy applicable to students with disabilities in FTI cases, it seems to me you can make a clearer differentiation and choose. Is Van Duyen the approach? If so, why, and how does that apply? Or in Bobby R., are you going to deal with not only benefit, but specific resulting benefit and significant and or substantial IEP provision? More work, but maybe a better payoff for both the law and for students. Or for those of you like me who are in the distinct minority, can you come up with, added to what Lynn had said, a cogent and fulfilling enough explanation that it would actually cause the courts to reconsider and say, wait a minute, I like Ziad's approach here, and I'm going to go with per se. And by the way, some of you pointed out this interlocks with the notion of remedy, but I purposely steered clear of remedy just so we would have enough time to just digest and deal with this issue itself. But it seems to me those are the choices. As you consider those choices, a couple of quick caveats. First, just as a reminder from what we said before, because it bears reminding, some of the attorneys and some of the pro se parents are not going to understand this unless you make it quite clear. If we're talking about an FTI case the way this material is arranged, we are limiting ourselves to the did not the would nots, not the could nots. This is the did not implement. And second, we have this problem that is specific to your jurisdiction. How do you do this RE, modified four corners approach, having to do with exclusion of retroactive evidence, that is, evidence beyond what's written in the IEP, except if it's there to just sort of clarify ambiguities in the IEP. And my tentative answer, but I always, when I interact with colleagues from New York, I always learn something, and I wouldn't be surprised if I missed something and was wrong, but my at least initial impression of where does RE fit, it would seem to me RE fits only with regard to the first of the two questions, which when I was disagreeing with Joel, I was saying is, what does the IEP provide? There it would seem to me RE applies. I'm not going to accept and rely on testimony saying you were going to provide an NE02 even though it didn't say so. Or mom said she heard somebody say that or whatever. That's all extrinsic to the IEP. On the other hand, getting to this notion of 1 hour, and does that mean 50 minutes of direct, or does it mean 60 minutes? There it would seem to me that evidence is clearly admissible to clarify what is the mutually understandable intent of 1 hour. Now, so my simplistic so far halfway through the answer is, I think RE applies to the threshold issue of baseline. What does the IEP require? However, my view is, how could it possibly restrict evidence to the second ultimate part, which is what is the extent of non-implementation or implementation? How can you possibly determine what happened in terms of implementation without looking beyond the IEP to see what the heck did the teacher do once you decided what the baseline was? That is, did the kid get the assistive technology? Did the kid get 50 minutes or 40 minutes or 30 minutes? It seemed to me you'd have to look at evidence beyond the IEP, which is, you know, sort of, I said here retroactive. Now I look at that. It's not retroactive. It's retrospective evidence. It's a typo that I'll have to correct, but that's retrospective evidence. That's my initial impression. Now, as you digest that, let's go to the next last code business. Stay steady. Dave Steady, have I lost you? Hello? Hello?
Code number 4 is on your screen.
Me.
I hear you, Perry. I hear you.
Good.
Code number 4 is on your screen. Please make sure you document code number 4 in your affirmation form. We'll leave that on for a minute or so. Perry, I just there's a comment that came in while you were speaking. An issue that sometimes come up is a complaint that some related service time was not used for the related service in the couple of weeks before state tests or finals so that the student could get extra test prep, help, or individual study time.
Interesting. That's an issue I never thought about, but I'll give you my initial impression. But remember, I'm more of the per se type. My view is, if you're trying to help a kid with a test, that's really self-interest. The test that you're typically talking about at the end of the year is, I guess it depends. If you're talking about the NCLB type or now ESSA test to measure accountability of the school, in my view, helping the kid there is the secondary aspect, and if you're doing so at the price of FAPE, then it's non-implementation, and you've got to make up that time. If, on the other hand, it's, I don't know, the Regents exam, and it's showing general progress in the general curriculum, and it's going to be important to this kid's life, and is ultimately more significant than the related service, then I suppose then it would be more excusable. But just simply the fact that kids it's like in June or whatever, they put the books away and none of the other kids are getting instruction. If it's my kid and the IEP says he's supposed to be getting an hour of specialized instruction, in my view, if you don't give it to me, I've got a right that the other kids don't have, which is to go to due process, go to a hearing officer, say this is a significant provision to my kid. My kid, being a kid with disability, needs this extra service. It's written down, and they didn't provide it, and their excuse is they didn't provide it to the other kids. Well, that doesn't fit under 504, much less not fitting under IDA. But again, I welcome the comment in terms of reality, and what it hopefully triggers in the rest of you is some of you will strongly disagree with me, some of you will modestly disagree, some may even agree, but it poses a very clear-cut example of an FTI case that you may well have to decide in the future using one of these approaches.
Another hearing off. Just one last comment. Another hearing officer related to what we were just speaking says that sometimes students don't get related services the first couple of weeks as school begins and the end of the school year in order to implement scheduling procedures.
Again, another good example, and we appreciate getting these doses of reality. Some of you are going to regard that as just simply an understandable price of doing business. Others, like me, say just because it's administrative convenience for the district as a whole, if the school year started on a given day and the IEP was supposed to be implemented starting on that day, and it seems to me that counts as non-implementation. And if you add it to what the other person said, that is that there was an absence of some weeks in the beginning and some weeks at the end, all the more that there's been more than a de minimis. Now, some of you are going to say, yeah, but if the IEP was reasonably calculated and we don't do it for other kids, then no violation. Up to you, but helpful again. I'm going to move on because
okay. Thank you.
Thank you. The practice pointers are put in more detail on your outline. I'm going to go through them fairly rapidly so that we have a chance to hear from Joel and Lynn, and also any of the rest of you want to chime in on reapplying now with this information the case scenario answers, but putting it in phases. Before the hearing, whether you have a pre-hearing session as has been recommended to you, or for reality reasons or otherwise, there's no pre-hearing session, but there is the very beginning of the hearing when you have an opportunity to interact with the parties and set expectations. First thing you'd want to do, it would seem to me, after a webinar like this, is say, did I duck a bullet? Is FTI an issue in this case? And the first place to look, of course, would be the complaint, but sometimes that's not all that clear, and you have to get more information from the parties. But if is FTI an issue? If it is an issue, then quickly, again, it would pay to just sort of review this information just so you have a clearer idea as to how these things fit, and to organize your clarifying questions for the next step. The next step being, oh, I'm sorry, that was all in preparation. Now we're at the pre-hearing conference or the outset of the hearing. We want to confirm that it is an issue. If it is an issue, then if you have an inkling towards, let's say, the benefit approach and Bobby R., and that's your view, it seems to me that it would be both fair and useful for both the parties and yourself for you to be upfront about that. If, on the other hand, you want to say to them, you read the jurisdiction as being unclear at this point, you haven't decided, give them an opportunity to provide their arguments as to which of the approaches applies, and each other to rebut each other, and then make your expectations clear. So, for example, someone like me who says I'm using the per se approach, you can appeal my decision, but I want you to be prepared that anything more than de minimis, I'm going to be looking at that, and so couch your evidence accordingly, and be if you think I'm really wrong, be ready to, if you can't convince me here, convince me in closing arguments or appeal the decision, but just to be fairly transparent about it. Then at the hearing, then we want to move ahead. Now, when I say rifle-like focus, I mean, using this analogy, it's not this shotgun of would not and could not, and it's just did not. And what I want to know in this case, as I listen to the questions, etc., what, as a baseline, what did this IEP require when understood in context of state law and local practice and policy? And then second, did they do it or did they not do it? And for those of you that are into this benefit notion, and what effect did it have on the child, or overall did the IEP, was it reasonably calculated? And something that we have not faced here, but just to sort of forewarn you, the most typical remedy in an FTI case, the most typical remedy would be compensatory ed. Going back to the McDonald's hot meal again, is it the juice? Is it the cheeseburger because of the lack of cheese? Or is it, the corner of a napkin that's otherwise available to you? And then you run into, if it is compensatory ed, is it a qualitative approach or a quantitative approach, for which the Second Circuit and New York still have not resolved this matter, and so you have some latitude there, or to use a sort of a hybrid approach. But occasionally, especially those who practice as hearing officers in New York City, you may well find that FTI is one of the claims in a tuition reimbursement case, and one of the alternative claims where the parent is saying, even if the IEP was substantively appropriate, even if the school had the capacity to implement, even if there were procedural violations that were not remediable because they didn't have an effect, there was a material shortfall in the implementation of the IEP. However, in my view, it doesn't fit very well, because if there was material denial, that was last year. The tuition reimbursement is typically for the year after that. The only relevance I can see is the parent who says, and because they didn't do it and I had to help my kid, that's when I placed my kid. So I think the fit with tuition reimbursement is less harmonious than compensatory ed. Don't forget at the end, like in our little case scenario, you got to write it up. And the first point is the factual findings. What did the IEP require? So was it 60 minutes or 50 minutes? And do you regard as needed as being a nullity, or is it all the time, as Joel said, for that assistive technology? And then second, as a factual matter, this is not a legal conclusion, it's a fact. To what extent was there implementation? When you move into the identification and application approach, it seems to me you've moved towards legal conclusions. Contrary to what one of you had commented earlier, I don't view this as a matter of fact. It seems to me this is either a matter of law or it is a hybrid matter, of a mixed matter of fact and law. But which approach, and for example, if you used Bobby R., which are the IEP provisions that are significant or substantial? To me, that's a legal conclusion, not a pure factual finding. Then, once you've identified the approach, let's say you followed the AP versus Woodcock approach, you end up citing, you say it's a mix, a blend of AP and Van Duyen. You cite both of them, and then you apply them, talking about whether there was a material shortfall, and if so, whether it was harmful in terms of benefit. And then I recite for you something that the courts have not held themselves to, but tend to hold you and the review officer to. And in my outline, I cited one Second Circuit case that says, if you are careful and thorough, and the review officer is not, then the court defers to your decision. So it seems to me, both in terms of coming up with a law that is more crystallized and more equitable and effective, and in terms of defensibility of your decisions and discouraging appeal, because they are being careful and thorough in this matter, it would seem to me benefits everyone. Let me stop for a second. We're about to return to the case scenario, but Data Study has been very good in letting us know about comments and questions. Are there any before we get back to our case scenario?
There is related to the practical approach, so I'm going to limit it to that for now to give you enough time to finish up. If it is not clear that the case law as as to what legal approach governs. I don't think you can set the standard up front, but must let the parties present their evidence at hearing and argue in their closing briefs what standard you should apply.
And that's certainly one very justifiable approach. But remember, it's set on an assumption that there is no clearly established approach. So then it seems to me, let the parties know that that's your reading of the law and give them the opportunity to argue whichever approach. But it seems to me that although it's not clearly settled in New York as to which of the three, it seems to be more clear than I'd like it to be that the per se approach is going to be very hard to establish because the Second Circuit and the lower courts, none of them have adopted it, and all of them have cited Van Duyen and or mostly and Bobby R. All right,
but Perry, just going back to your comment on the rifle type of approach, if you wait to the end for the parties to then try to convince you which approach they believe you should apply, and you don't have this discussion up front, does it?
Yeah, good point. Yep.
Would it then require more evidence to come in than would be required depending on how you would have ruled on the issue?
You're right. You're right. If you sort of allow the target to be very flexible there, then you're going to get a shotgun rather than a rifle. And the trade-off is that although you give the parties the opportunity, it makes for a much longer hearing. So any of this that you can sort of narrow and resolve and get it down to one barrel, it seems to me helps everyone in terms of transaction costs. Okay, I'm going to go back. Joel, I'm going to put you back on the spot here, and you've been very kind about all of this, including my, vociferous disagreement on some little things that I've learned from you overall. But is your view the same? That is, if you looked at the three together, and we might as well, for the sake of time, see whether any one of them alone, but was there a denial of FAPE in the case that we presented with regard to cumulatively all three of these or any one of them, in your view, and tentatively which approach sort of led you that way?
I have a little different view of the whole thing, and you'll forgive me. I have a different background than most of you, and I'm very child-oriented and progress-oriented, and I go back to Bloom's taxonomy of educational objectives. The things are measurable. Both affective or, just real testing really works if it's not standardized testing. And for each issue in an IEP, there should be a basic present level of performance. There should be goals and measurable objectives. I think that's been in the law for years. What I'm seeing with these computer-generated IEPs, we've lost all that.
What about this case?
In this specific case, we don't have the information here.
Oh, now, how many times have you had, because it certainly happened to me many times, that I finally get to the case after all these sessions and I find there's some key information that's missing? I can't go back and ask for a new hearing.
Well, what I tend to do is during the hearing, I give myself an opportunity, if there are open spaces, in my opinion, of asking questions. Because I want to have a complete record. When you're looking at the need for...
You're not going to decide this, okay?
I'm not.
Is that my understanding? All right. To me, that's what's the word here? Copping out, but nevertheless, that's your choice. Lynn, are you willing to make a decision?
Oh, I'm always willing to make a decision, and the answer on the consulting teacher.
Yeah.
Now, mind you, I come at this from the per se approach as you do, but I still believe whether we find a violation with a per se approach, we have total discretion to come up with the appropriate remedy.
What might it be?
I don't look at it as a cookie cutter thing, to use an analogy to the comp ed thing. I mean, I think we have total discretion. So I'm going to find that their consulting teacher was a violation. But like Joel, I would want to know some information with regard to how that teacher actually worked and worked with the student, and how the student did in the classes where the consulting teacher was consulting. on number 2 on the OT
Yeah,
service.
Wait, I realize, I appreciate the fact that you were making a decision. Does it make it any easier for you if, again, based upon the comments that folks had said, that this was direct, that it's allowed under state law, and this IEP actually said the consulting teacher will provide direct services to the child, not just consultation to the teacher? Does that move you towards a remedy, or you still need more information?
I need more information because I don't rely on paper. I want to know how that teacher actually performed regardless of her certification. He could be damn good.
Yep, and that introduced the issue we've talked about before of the remedy often being something that some folks reserve for a bifurcated kind of notion. But in any event, you were moving to the second, which was the OT and SLT.
Yes, and there I think I would agree with Joe. I have to know whether the parent knew that or not in terms of the practice or whatever. And I think that's a critical fact. And if the parent didn't know it, violation. If they did know it, no violation.
And Perry, let me add one more point to that, if I can.
Gentlemen, for a minute, just for a minute. Perry, just flip the slide to put up the last and final code. I want to make sure we put it up there at 8 o'clock.
Good.
So code number 5 is there. We can continue the discussion, but for those who need to sign off, because it is 8 o'clock, you can do so. But continue now. Thank you.
Good. What were you going to say, Joel?
There's a point in therapy that compensatory might mean another 10 minutes or 15 minutes, but there's a reality that a child might only be able to handle it for 50 minutes or 40 minutes. And then but
the per se folks like me would say that you should have considered that when you wrote the IEP.
But it might be that session. No, I understand that, but that's a reality in speech therapy and OT and PT and all this kind of stuff. The child may not be able to go further, and may, by going further and pushing the child further, may be negative.
Then it would seem to me you just reconvene the IEP team and say 60 minutes is too much for this kid. We'll make it 40 minutes.
But it might be based upon that session. A therapist needs to have, in other words, the fact that they have it the same every time is the weakness of their case.
I think you're going beyond the scenario, though, in that regard.
Yeah,
you're probably right. Sorry.
Well, I'm gonna give.
Let Lynn decide the third one just for a second.
Well, on the third one, I initially said no, but and that's because of the words "as needed," as I noted before. That's just terrible IEP drafting.
Yeah.
So I would actually have to know some information with regard to how, in effect, that worked, and whether the kid did okay with a PC, and who made the decision, and did the kid, the teacher, and all that.
And just reviewing this for a quick second, because we're just wrapping up now. You, Lynn, if I hear you correctly, you always have creative ways of applying it, but you're leaning toward the per se approach, correct?
Yes. Yes.
Yeah. And Joel is saying none of the approaches. We're going back to Bloom's taxonomy, and you have to be as old as me to understand what he's talking about.
No, I'm not. I'm actually saying it's based upon the child's performance and what the needs are and how the equipment is being used, and on and on and on.
Which of the three approaches? I guess Joel is not answering it.
I'm not answering.
Thank you. Dave, steady?
Yeah, well, folks, I appreciate the conversation, and I'm sure we can folks on for the next hour, but I'm sure you want to go and have dinner just as I want to go off and have dinner. I want to thank you for your time and commitment to, this evening. We will gather again in March for the second webinar. I will be sending out information regarding that registration information. Nothing to do now. Make sure you send me the affirmation forms via email or fax or by mail. And also, when we sign off, you will have an opportunity to provide feedback on tonight's session. Please fill that out and send it in. Thank you again, and have a good night.